Hey, Brian Parker here again. I just did a video on against Discover Bank, a video on instructions how to combat them. And I've been touching upon the role of the mini Miranda warning in some of these lawsuits. They're increasingly showing up in a lot of creditor lawsuits. Now, keep in mind, in a lot of states, one of the exceptions is Florida, when you're being sued by a creditor, you don't have the protection of the FDCPA against the plaintiff, which would be, in the last video, would be Discover Bank. That's a creditor that you signed up for the debt with. So generally, as an attorney that's trying to get people out of these debts, my options are limited. And then came securitization. And that was massive. That just got in my consciousness, and you've seen all my videos. See all my videos on securitization, and then whoosh. See the video I just did on fighting a Discover Bank lawsuit. There it is. Now swish. So what's the role of the mini Miranda warning? That's under 1692E11. And that a mini Miranda, as you probably know, it appears on all forms of debt collection communication. And it says when you initiate contact with a debtor, 1692E11 says you must place in the mini Miranda warning in your communication. However, at the bottom of that section of the FDCPA, it says this isn't required in pleadings. You're not required because you don't want to make that a collection communication. A debt collector does not want to do that because right back at you, now you've got to do a validation letter and then they get to respond, and it ties up pleading. So the federal rule is a pleading is not an initiation of a collection attempt under the rule 1692G when you have to give people their validation rights and verification rights. It isn't considered an initial communication. The beginning of 1692G, let me put it on, says 5 days after the first contact or initial contact, you have to tell people their rights under the FDCPA. That's not the case with pleadings. However, now debt collectors, let's say debt collectors are putting on their pleadings for creditor clients. We are debt collectors. Anything you say will be used for that purpose. I'll put on two examples to show you what I'm talking about. Shazam. And you can see both of these, the debt collectors saying we are debt collectors. But the debt collector under law is protected from having rights and responsibilities under the initial contact rule. This isn't an initial contact for collection attempt. But when they put the mini Miranda on a pleading, they screw everybody up and they screw their clients. Trust me. The clients being the creditor client. So now it says we are debt collectors. Now that's the debt collector placing that on the pleadings for the only person in this lawsuit that's suing my client. In this case, it was Discover Bank. They now have made Discover Bank or any creditor a debt collector. You're not required to do that. E11 says don't put it on pleadings, but when they do that, why are they doing that? Well, let me tell you the consequences of doing that. If you're a Parker disciple, or if you're on the other end of a Parker pleading, you have to validate the debt. You, Discover Bank, are now treated like a collection attorney or a debt collector. And if you don't validate, because I rightfully argue you have to, I can hold that against you and should. You should hold that against them. And it's another brick on the wall against these guys. The law firm is putting it on there. It's just, there's this such CYA and belt and suspenders on the collection side of things. They just are fearful that they will be sued. So they're putting we are debt collectors for themselves, but their real plaintiff and their client is now suffering consequences. But the debt collector's covering itself, so it's doing its client creditor no favor, because somebody like me is going to come along and go, wait a minute. Now, if Discover Bank says, no, we're not debt collectors, this is the law firm doing this, they've got another problem. Look under 15 USC 1692J. And that's essentially, you're not allowed to furnish deceptive forms. The creditor that does that is now subject to the FDCPA. And also look under 15 USC 1692A6, which is called the false name exception. So if you put a false name and imply that somebody else is collecting when it's really you collecting, you're pulling the strings, that's a violation of the FDCPA. So there's all sorts of ways that you can get these guys that are wink wink using their debt collectors attempt to protect themselves on their own. I'll tell you what that means. If you receive communication that says we are debt collectors, anything you use will be used for that purpose, it makes your knees knock. It's a way to scare people. So the creditor can be legitimately accused of using collection attempts while at the same time saying we're creditors, and under the FDCPA, creditors are immune. So if you have that mixed messages, I call it the mixed messages doctrine, the law says, wait a minute, you're purposely using the FDCPA to collect and using the FDCPA to protect yourself at the same time. Mixed message goes against the drafter. Most contracts, if there's ever a problem in a contract, whoever wrote the contract, there's an axiom in law, it goes against the drafter of the document. Well, if these mixed messages are in a Discover Bank lawsuit, hold against the drafter. So you can hold their feet to the fire with the debt collection response. So what I do is I put this right in my counter affidavit, as you know I do, when I have a creditor client. Remember the distinction between creditor clients and debt buyers. So I put that in both my answer, my pleadings, and my counter affidavit. And now what I want you to do is send a validation letter to Discover Bank. And I'll put it on this website. I'm going to put the show notes for my membership website, collectionstoppersolutions.com, as I always do. And I will put a nice validation letter for you to use. This is just a quick video. I just want to update you. And then send that validation letter. The number one reason you do that is to legitimatize your defense. This is a debt collector now, and I can sue them under the FDCPA. It's almost, it behooves you to do that. Because if you really believe they're debt collectors, then you must respond to your validation response. So I'll put a couple of letters on this video for you on my membership website that will gut them out. When you go before the court, Your Honor, not only do I believe they're debt collectors, because look, they say we are debt collectors. I sent them a validation letter and they did not respond. And under 15 USC 1692G, to bring this back to full circle, a failure to respond means they cannot collect. They are treating listen to this. They are treating the collection lawsuit as a collection attempt by saying we are collecting. Therefore, they must cease and desist under 1692GB, which specifically says you must cease and desist if you receive something in writing. So jam them, support yourself, make this case and defense so strong that they settle with you either for a debt elimination, it happens, or you get a really good deal. Because they don't respect you, this brings automatic respect. I hope this mini Miranda warning explanation on a creditor lawsuit makes sense. Comment, call me if there's a problem with this, you need more. Love, like, subscribe, and go get these guys, all right? Thanks.